Now we will look at suspension and expulsion of trading membership. As indicated, the suspension and expulsion of trading membership takes place in various situations where the trading member is not properly following the rules, regulations, or trying to misguide or have misconduct on the part of the operations by the trading member. The exchange may expel or suspend, fine under censure, or warn or withdraw any of the membership rights of that particular trading member if it is guilty of contravention, non-compliance, disobedience, disregard, or evasion of any of the bylaws, rules and regulations of the exchange, or any of the resolutions, orders, notices, directions or decisions or rulings of the exchanges or any relevant authority. What are the bases for suspension of this particular membership? It can be due to misconduct, unbusinesslike conduct, unprofessional conduct, trading members' responsibility for partners, agents and employees, and suspension on failure to provide margin deposit and or any capital adequacy requirements. Now these are the basis why the suspension of the trading membership can take place. Now let us try to discuss what constitutes the misconduct of the trading member. The trading member is guilty of misconduct for any of the following reasons: act of fraud, if he is convicted of any criminal offence, violations of the provisions of any statute governing the activities, business operations of the exchange, improper conduct of the trading member, failure to submit or abide by arbitration, failure to testify or give information sought by the exchange or any committee or any person authorized on that behalf, failure to submit special returns in such form as the relevant authority may from time to time prescribe, failure to submit audited accounts, failure to compare or submit accounts with defaulter, failure to submit or make any false or misleading returns, make vexatious, malicious or frivolous complaints, failure to pay subscription fee, arbitration charges, etc. All these points constitute the misconduct by the trading member and he can be gone or sent for suspension. What are the activities that come under unbusinesslike conduct? Transaction or business dealing in fictitious names. If he carries out, then he can be considered as unbusinesslike conduct activity. Such activities can be taken under unprofessional or unbusinesslike conduct and sent for suspension of trading membership. Circulation of rumors, any unfair dealing in securities which does not reflect true market values, market manipulation and rigging activities, unwarrantable business which affects purchases, sales for its accounts or any account related to the trading member. If a trading member accepts less than a full or and bona fide money in settlement of a debt due by another trading member arising out of a transaction in securities. That means if he accepts less money for the actual amount he has to receive, that is also conducted as activity and unbusinesslike conduct. Dishonored checks by this particular trading member, failure to carry out transactions with the constituents properly also constitutes unbusinesslike conduct of this particular trading member. The third category, unprofessional conduct. A trading member is deemed guilty of unprofessional conduct for any of the following acts or omissions, namely business in securities in which dealings are not permitted. He is transacting securities which are not permitted for transactions at the exchange, and he is carrying out a business for defaulting constituent who failed to carry out engagements relating to securities and is in default to another trading member. that means he is supporting a default trading member, transacts in business with an insolvent without obtaining the consent of the relevant authority, even if the individual has obtained his final discharge from an insolvency court. Carrying out his business during his suspension period. When he is suspended, he is doing some sort of a transactions involves unprofessional conduct, business with suspended, expelled and defaulter trading member. So he is trying to support other trading members who are not active members. Business for employees of other trading members, he is carrying out a business for employees of other trading members. Business for exchange employees if it makes a speculation transaction in which employee of the exchange is directly or indirectly interested in. So he is supporting a exchange member who is having direct or indirect interest in that particular stock. If it advertises for business purposes or issue regularly circular or other business communications to persons other than its own constituents, trading members of the exchange, banks, joint stock companies, or publishes pamphlets, circulars or any other literature or report or information relating to the stock market with its name attached. Evasion of margin requirements, that is not paying properly the margin requirements and trying to involve in evading or avoiding the tax. Evasion of brokerage charges, not able to pay the proper brokerage charges. Dealing with entities which are prohibited by SEBI to buy or sell or deal in securities market. So all these constitute unprofessional conduct. Trading members' responsibility for their partners, agents and employees. A trading member is fully responsible for acts and omissions of its partners, authorized officials, attorneys, agents, authorized representatives and employees. Any act is against the relevant rules and regulations is committed or omitted by these people who are related to trading member, this particular trading member is liable to the same penalty to the same extent as that act or omission has been done or omitted by itself. That means any acts of the people related to this trading member will constitute as if it is the act of the trading member, or any liability, anything which are applicable will be applicable to the trading member himself. Suspension on failure to provide margin requirements and capital adequacy requirements. The exchange can suspend the business of this particular trading member when this trading member fails to provide margin deposit and or meets capital adequacy norms as provided in the bylaws, rules, regulations of the exchange. The trading member shall remain suspended until he furnishes the necessary deposits and margin as per the rules and regulations guidelines provided by NSE and SEBI from time to time. Now we have seen suspension, how it is done. We will see about suspension of business. The relevant authority may require a trading member to suspend its business in part or in whole under following conditions: prejudicial business, unwarrantable business and unsatisfactory financial condition. When the relevant authority finds that the trading member conducts business in a manner prejudicial to the exchange by making purchases or sales of securities or offers to purchase or sell that securities for the purpose of upsetting the equilibrium of the market or bringing about a condition of demoralization in which prices will not fairly reflect market values. So the business can be suspended of this particular trading member if he is carrying out a prejudicial business. The second situation in which the suspension of business of this particular trading member will be done on unwarrantable business. When the opinion of the relevant authority, the trading member engages in unwarrantable business or effects purchases or sales for its constituent account or for any other account in which it is directly, indirectly interested, which purchases or sales are excessive in view of its constituents or its own means and financial resources or in view for such securities. So that means if a trading member is entering into excessive transactions over and above their limitations, it can be constitute as unwarrantable business and can be liable for suspension of the business by the stock exchange. Unsatisfactory financial condition. When the relevant authority finds that the trading member is in a bad financial condition and it cannot be permitted to do business with safety to its creditors or the exchange, they can suspend the business of that particular trading member. So please remember, for suspension of business of the trading member, three things are important: prejudicial business activity, unwarrantable business, and unsatisfactory financial condition of the trading member can involve them into suspension of business. Earlier one what we discussed was suspension of trading membership when they are involving in misconduct. Now once a suspension is done of the trading membership or the business, how that suspension can be removed, or the ruling of suspension on that particular trading member, how it can be removed. The suspension of business as above shall continue until the trading member has been allowed by the relevant authority to resume business. So till the authority does not clear the suspension, he will be under the suspension of business purview only. It may be done on its paying deposits or doing any such activity or providing such thing as the relevant authority may be satisfied that he has now fall in place as per the rules, regulations, and proper deposits are being paid. Then the relevant authority may clear the order on suspension of business for that particular trading member. What are the consequences of such suspension? What can happen when the suspension order by the relevant authority has been issued? The suspension of a trading member will have the following consequences: suspension of membership rights, rights of creditors unimpaired, fulfillment of contracts, further business prohibited, trading members not to deal with suspended trading member. These are the consequences of suspension. Let us try to see one by one. The first one is suspension of membership rights. The suspended trading member shall during the terms of its suspension period be deprived of and excluded from all the rights, privileges of membership of NSE. It shall also include the right to attend or vote any meeting of the general body of trading members of the relevant segment. So they are not allowed for the rights of the trading members. Rights of creditors unimpaired. The suspension should not affect the rights of the trading members who are creditors of the suspended trading member. Though the trading member is suspended, he is liable and he is supposed to satisfy or pay the creditors of other trading members. Fulfillment of contracts. The suspended trading members are bound to fulfill contracts that are outstanding at the time of its suspension. Any contracts, any transactions which are still pending at the time of suspension order is released, they are supposed to fulfill the conditions or transactions properly. The suspended trading member will not be able to carry out further business, and that will be prohibited with the permission of the relevant authority. However, it can close the transactions outstanding at the time of its suspension. Trading member is not supposed to deal with suspended trading member. No trading member is allowed to transact in business with such a suspended trading member during the terms of its suspension, except with the prior permission of the relevant authority. So no one is supposed to do any sort of business with the suspended trading member. If they would like to do it, they need to do it prior permission from the relevant authority. Now, expulsion. What are the consequences of expulsion? The expulsion of a trading member has the following consequences. The trading membership rights are forfeited, office is vacated, rights of the creditors unimpaired, fulfillment of the contracts which are pending at the time of expulsion, trading members not to deal with the expelled trading member, and consequences of declaration of default to follow. These will be the consequences of the expulsion of the trading member. Now let us go one by one. First, trading membership rights are forfeited. The expelled trading member shall forfeit to the exchange its right of trading membership and all rights and privileges as a trading member of the exchange, including any right to use or any claim upon or any interest in any property or funds of the exchange. But any liability of any such trading member to the exchange or to any trading member of the exchange shall continue and remain unaffected by its expulsion. So they are not having any right to use the facilities of the exchange, and whatever due by this particular expelled trading member has to be fulfilled to the exchange or any other trading member. The office has to be vacated. Rights of creditors unimpaired. The expulsion does not affect the rights of the trading members who are credited to this expelled trading members. Fulfillment of contracts. The expelled trading members are bound to fulfill transactions outstanding at the time of expulsion order released, and it may, with the permission of the relevant authority, close all such outstanding transactions with or through a trading member. Trading members not to deal with expelled trading members. No trading members is allowed to transact business for or with or share brokerage with the expelled trading member except with the prior permission of the relevant authority. Consequence of declaration of default of this trading member will follow. The provisions of pertaining to default and protection fund mentioned in the bylaws become applicable to the trading member expelled from the exchange as if such trading member has been declared a defaulter. Declaration of defaulter. Now let us try to understand how a trading member can be declared as a defaulter and what are the consequences of a defaulter as a trading member. First of all, a trading member may be declared a defaulter by direction, circular, and even by the notification of a relevant authority of the trading segment. When this notification is declared, the trading member will be assumed as defaulted in various segments of the stock exchange. Now, when he will be declared as a defaulter, under these conditions he can be declared as a defaulter. The one point is, if he is unable to fulfill the obligations which he is supposed to fulfill, or if he admits or discloses his inability to fulfill or discharge his duties, obligations and liabilities, or else he can also be declared as a defaulter in case he fails or is unable to pay within the stipulated time the damages and the money difference due on a closing out effected against him under the bylaws, under the rules and under the regulations. Alternatively, he can also be declared as a defaulter if he fails to pay any sum due to the exchange or to submit or deliver to the exchange on the due date, delivery and receive orders, statement of differences and securities, balance sheet and such other clearing forms and other statements as the relevant authority may from time to time prescribe. Trading member can be declared as a defaulter by a relevant authority if he fails to pay or deliver to the defaulters committee all monies, securities and other assets due to a trading member who has been declared as a defaulter within such time of the declaration of default of such trading member as the relevant authority may direct, or if he fails to abide by the arbitration proceedings as laid down under the bylaws, rules and regulations. Without prejudice to the foregoing, if a trading member is either expelled or declared a defaulter by any other recognized stock exchange on which he is a member, or if the registration certificate of such trading member has been cancelled by SEBI, in such cases the trading member is said to have been expelled from the exchange permanently. Let's try to now understand about authorized persons. First of all, let me try to give a brief about authorized persons, then we will go into the details about authorized person. Who is an authorized person? A trading member can appoint an authorized person to help in the buying and selling and also involving in the transactions of securities, creating a client base for the trading membership business. These all activities can be sought from this particular authorized person. So a trading member can appoint an authorized person. A trading member can appoint an authorized person to support his transactions, his business. This particular authorized person is acting on behalf of the stockbroker or the trading member, but he has no direct relation between the transactions of the clients and that of the trading member. He is only playing a support role to the trading member, and he is just in between the trading member and the client. However, the transactions the client makes through this trading member is having a direct relation with the trading member himself. So whatever services this authorized person is rendering, either from the client point of view or from the trading member point of view, he is eligible for certain fees, commissions, charges, etc. from the trading member, but he cannot directly bill to the client, nor he can bill to the trading member. So the trading member will in turn pay certain commissions for the service rendered by this particular authorized person. However, once the client has been introduced by this particular authorized person to the trading member, client trading member will be having a one-to-one relationship. The trading member will be providing service to the client as if the client belongs to trading member only, not for the authorized person. So authorized person has no saying or no relation with respect to the transactions that are taking place within the exchange through this trading member by the client. So if a client is placing order with the help of the trading member's registration, the securities will be delivered to him and monies also will be delivered to him from the trading member directly, and he is liable to pay or deliver securities to the trading member directly. So authorized person is just playing a support role only. Fine. Now let's, with this brief understanding about who is an authorized person, we will try to get into details about what are all these implications or systems with respect to authorized person. Trading members of the exchange can appoint authorized persons in the capital market, in the futures and option market, and currency derivative segments. Authorized person can be any person. He can be an individual, he can be a partnership firm, he can be a limited liability partnership or body corporate, who is appointed as such by a broker and who provides access to trading platform of the stock exchange as an agent of the stockbroker. So this authorized person works as an agent for the stockbroker. authorized person can receive remuneration in terms of fees, charges, commissions, salary, etc. for his services only from the stockbroker and shall not charge any amount from the clients. Accordingly, stockbroker can share brokerage with the authorized person but shall not charge any amount directly from the clients. The clients introduced by this authorized person should have a direct relationship with the trading member. That is, the member constituent agreement, know your client forms, risk disclosure document, etc., which generally a trading member have to get the signatures done by the client, will be done by trading member with the client directly, and these are executed between the client and the trading member. This implies that authorized person is not allowed to have any trading relationship with the clients. The trading member should issue contract notes and bills directly to the client. So whatever transactions the client is making, the trading member will raise the contract notes and bills on the name of the client. That is, the authorized person should not issue any contract notes, confirmation memo, and or any bills in their name. This is important. So authorized person is not authorized to issue any contract notes or bills. It is the trading member who will be issuing the contract notes and the bills on the name of the client. The clients introduced by the authorized person are required to deliver securities and make payments directly in the name of the trading member as it is appearing on the SEBI registration certificate issued to the trading member. Similarly, the trading member should deliver the securities and make payments directly in the name of the clients. This is what is important about authorized persons. So authorized persons are only playing a support role, but they do not have any direct relationship with the transactions of the client through this particular trading member. All the transactions will be billed and received between the trading member and the client themselves. So authorized person has no role in this particular situation. He only helps to introduce and support the trading member in generating business, in generating new clients. Now, we have seen who is a trading member or a stockbroker, how he is having a relation with the exchange, and how he has to follow various rules, regulations, various certifications, various approvals, various registrations from SEBI, and then start his business of providing service of buying and selling of securities. Now, a stockbroker, to help promote his business or to extend his operations, he has got the right to appoint a stockbroker's subbroker. That means this subbroker is in turn an intermediary between the stockbroker of the exchange and the client.